My name is Tommy. I am a Murphy Scholar. I'm a 2L here at St. Thomas as well. We're excited to welcome you here today. Very briefly, the Murphy Institute is a collaboration between the Center for Catholic Studies and the School of Law that works to engage the Catholic intellectual tradition and the practice of the legal profession together in a way that creates meaningful discussions and debates on the law and public policy through the lens of Catholic contemporary perspectives. We're excited to welcome you to Hot Topics Cool Talk, Qualified Immunity. What is it, and is it good or bad law and policy? As part of the Hot Topic Cool Talk series, this program will feature 2 legal scholars with contrasting views on the legal and policy merits of qualified immunity, participating in a spirited yet civil conversation. For this talk, we feature Professor Christopher Walker from the University of Michigan School of Law and St. Thomas's own Professor Gregory Sisk. There will be some time for some Q&A as well after the preliminary presentation here. For those that are joining online, Michelle is going to drop in the email address, which you'll use to email for CLE credit. You can also use the Q&A function in there as well to ask questions for our in-person folks, especially our attorneys in the room. There's a sign right over here to make sure you grab that CLE credit as well. So now it's my honor to introduce our 2 speakers for this particular event. Professor Christopher Walker is a professor of law at the University of Michigan. Prior to joining the faculty in 2022, he spent a decade teaching at the Ohio State University, Moritz College of Law. He previously clerked for Justice Anthony Kennedy of the U.S. Supreme Court and served on the Senate Judiciary Committee staff for the Gorsuch Supreme Court confirmation. Professor Gregory Sisk is a professor here at the University of St. Thomas School of Law and serves as the co-director of the Murphy Institute. Prior to joining the faculty here at St. Thomas in 1991, he served in all 3 branches of the federal government. Notably, he served as a legislative assistant to a U.S. senator. As this is part of the Hot Topics Cool Talk series, both individuals will be discussing some different viewpoints, but I think it's really important to also share some similarities between these 2 professors. So I don't know if you knew this, but both Professor Walker and Professor Sisk worked for the civil appellate staff at the DOJ, and they were both clerks for judges in the 9th Circuit. So there you go. There's some 2 similarities in between these things. So we'll see how these go. So with that in mind, we're just welcome to Professor Walker and Professor Sisk.
Good afternoon and welcome on behalf of the Murphy Institute for Catholic Thought Law and Public Policy. Along with Monsignor Martin Schlegg, I am a co-director of the Murphy Institute. And I should say, the Monsignor is on a flight to Vienna today to join his family. His mother passed away. And so we send our prayers and love with the Monsignor as he travels across the Atlantic. For those of you who have followed the Murphy Institute for a long while, this is a long-awaited return to our Hot Topics Cool Thought series. We're delighted to have you here with us today. This series, the mission of this series is to address a topic that is hot and controversial and in the public eye, and to bring in people who will have a good faith civil discussion about it, and to model that it is possible to disagree about very important topics without assuming that your opponent is acting out of malicious purposes. So, Professor Walker will speak about, will present a qualified defense of qualified immunity. I would disagree with him, but I do not think that that means that he doesn't care about official wrongdoing or is speaking only to be an apologist for the powerful. I will present arguments against qualified immunity, but I insist it does not mean that you can label me as anti-law enforcement and not caring at all about the difficult job that public officials have. So for those of you who are perhaps less familiar with the Hot Topics Cool Thought series, but have heard of the Murphy Institute, you might now be asking the question, so what does this have to do with Catholic thought? And particularly, what is the Catholic position on qualified immunity? So I want to state definitively and authoritatively that the Catholic position on qualified immunity is that there is no Catholic position on qualified immunity. Right. This is one of those topics in which the church recognizes that prudential judgment will be left to those who are authorized by law to make these kinds of public decisions. The church doesn't have a specific answer. That's not to say the church doesn't care. The church certainly wishes to affirm those who hold public positions and are working to advance the public, the common good. And the church stands in solidarity with those who have been wronged by official abuse of power. But the church doesn't presume that theologians and priests have the answer to what is the right balance in public policy to achieve those purposes. And so that leaves us to talk about that. So the way this is going to unfold this afternoon is I'm going to begin with a primer on qualified immunity. Then I'll turn it over to Chris, who will offer some thoughts about the benefits of it. And then I will return to the podium to present some opposing views, and then we'll leave time, I do hope, and I think we will, for questions and thoughts from the audience. So most of you have heard of qualified immunity, but many of you, I suspect, aren't entirely sure what it means. And if so, you're in good company. There are a lot of lawyers, law professors, and public officials who really don't understand what qualified immunity is. So I'm going to begin with three mistaken notions about what qualified immunity is before I define it. So, first, qualified immunity simply requires that government officials act reasonably. Well, that's sort of true, but not exactly. To be sure, reasonableness is built in to some constitutional protections. The Fourth Amendment, for example, requires that searches not be unreasonable. So there's a reasonableness part of that. When we're talking about qualified immunity, we're talking about reasonableness in a peculiar way. And I'll say a little bit more about that in a moment. A second mistaken notion, which I've heard even professors express, is the concern that qualified immunity provides too much of a defense to police officers who are charged with a crime after a killing during in the line of duty. That is entirely wrong. Qualified immunity has nothing to do with criminal prosecutions. Qualified immunity is an affirmative defense that is provided in civil constitutional tort cases in which the remedy being sought is damages against the individual government officer who acted under color of law. In fact, even in a civil case, qualified immunity is not a defense if the relief being sought is equitable or declaratory in nature, such as obtaining an injunction against a government official in official capacity. The third mistaken notion is that qualified immunity is lost whenever a government officer has acted illegally in some sense, such as violating the criminal law or violating an agency policy. And to demonstrate this mistaken notion, I'm going to show you a couple of video excerpts. This is from a hearing before the Public Safety Committee of the Minnesota State House of Representatives just last year on a state proposal to abolish qualified immunity. And the first person you're going to see here is a county sheriff, and the second is a state legislator, both who are opposed to abolishing qualified immunity. And hopefully I can make this work. I need to do a couple of things, so bear with me. I need to turn up the sound. And then I'll turn it down right afterwards so you don't hear that buzz. Share the screen with this. There we go. Need to optimize. It's a lot of work for 1 minute of video. And I don't want that there, whatever that is. Here we go.
There's a misnomer that law enforcement feels like qualified immunity is some get out of jail free card. The attorneys I talk to say there's nothing further from the truth. The realities are qualified immunity does not protect law enforcement who knowingly violate the law. The view is that law enforcement is protected by qualified immunity, we feel is overstated.
as long as the officer is not breaking a law or violating the law or policy for that matter, he's protected. But if he violates policy, violates the law, qualified immunity does not fall in play. He is liable for what he does.
Turn down that buzz. Back to where I was. Wrong. What the sheriff said, what the legislator said is simply wrong. In fact, qualified immunity does not fall out simply because the officer has violated state law or a state policy. Qualified immunity is lost only when the source of the constitutional source of the law is at play. And we'll say more about this in a moment. So what does qualified immunity mean? Let's begin with what the Supreme Court's concerns have been in developing this policy. The primary concern that the Supreme Court has is that personal liability in a civil rights suit against a government officer may cause people not to want to hold public office. And those who are holding public office may be deterred from the faithful discharge of their duties. And so the court was looking for what it thought was the right balance. A balance between the evil of abuse of government office and the cost, the social cost of litigation, and determined that that right balance is what the Supreme Court has called qualified immunity. Now, defining the standard for qualified immunity, the Supreme Court has expressed the crucial inquiry as being whether the government official violated, quote, clearly established statutory or constitutional rights of which a reasonable person would have known. So what does that mean? It means we're looking at court precedents to determine what is the clarity of the law. And the Supreme Court has said, first, the law itself must be clear. That is, precedential decisions must have placed the statutory or constitutional question beyond debate. Second, precedent must also address the factual context, the factual scenario in which the government officer was acting. And that existing precedent must also place the conclusion that the officer acted unreasonably under these particular circumstances as also beyond debate. And the Supreme Court in recent years has reiterated that this must be done not at any level of high generality, but particularized to the particular circumstance that the government officer is facing. And with that, I'll turn it over to Professor Walker. Let me bring up his set of slides here.
I have to say, it's just so wonderful to be here and to be part of this Murphy Institute event with Professor Sisk, who's just an amazing scholar in person. And quite frankly, to be at this law school, there's just a lot of peace here. Really, really just a wonderful place. I'm fortunate to be here. I hope you feel that you're fortunate to be taking classes here or feel really just to spend a little bit of time on campus. So I've been tasked with defending qualified immunity. And I might say I'm going to partially defend qualified immunity. And I want to kind of walk through like why we have this doctrine and kind of walk through some of the first, as a matter of law, whether it's correct, whether the court should get rid of it. And then as a matter of policy, kind of walk through some of the empirical evidence that's been shown. And Professor just kind of already identified the social costs or the reasons why we have qualified immunity. I don't know the reason why we have immunities at all. Like, we have qualified immunities for executive officers. That's what we're talking about here. Judges have absolute immunity when they act in the judicial capacity. You can't sue them for damages. You can't sue them for injunctive relief with some narrow exceptions under the Civil Rights Act. And similarly, you can't sue a legislator when the legislator is acting in the legislative capacity. And the reasons why we have these immunities, as Professor Sisk mentioned, is that we're trying to help states recruit, hire, and retain the best people to do those jobs. And if they are going to be afraid that they're going to be sued, tied up in litigation, maybe have to pay out of their own pocket, but we'll talk a little bit more about that. those people. In fact, I think we kind of see that playing out right now. After the murder of George Floyd, and what we're seeing with police departments and their staffing over that. I'm not saying that's because of just qualified immunity, but it's not. There's a larger problem there, but it's important that the state be able to recruit, hire, and retain the best people to fill out those functions. Similarly, you want officers to be able to fully perform their duties rather than be distracted by litigation. So it's not just about the cost out of pocket, fear of losing your home, which we'll talk about. Indemnification doesn't happen as much today because usually officers are indemnified by their government, by their employers. To be put on trial before a jury and the like along those lines. So that's the reason why we don't have that. Now, when you think about judges, this makes a ton of sense, right? Judges, you don't want them when they're deciding the case to be worried about being driving to another court and being examined for how they decided that case. When it comes to executive officers like police officers, school teachers, social workers, and the like, it's a little bit more complicated. And the third one, and this is really important when it comes to executive officers, is you don't want them to be chilled from making tough decisions to faithfully execute the law. A lot of times, police officers, it's not a choice of whether to do nothing and no harm happens, or to do something that harm could potentially happen. Oftentimes, they're called into a situation where harm is going to happen no matter what. If they don't act, and they have to act and make a decision along those lines. And they have by default doing what they don't act to avoid liability in order to protect individuals in that situation. So that's kind of why we have these. These are the reasons the Supreme Court is given for immunities more generally. So when it comes to attacks on qualified immunity, on the legal side, lots of law professors have been making arguments that as a matter of law, qualified immunity is made up. We should get rid of it. I want to flag Will Bailey because he's viewed as conservative and libertarian, and this article had a pretty powerful impact on discussions because it wasn't just progressives arguing against immunities for officers. It was someone who's viewed as right of center, has been cited in a lot of the cases where the royal courts and the Supreme Court's been deciding whether to reconsider, narrow, or get rid of qualified immunity. And his basic argument is, if you look back at the founding of the Civil Rights Act, and I guess I should also just know, qualified immunity applies to federal officers and state officers. I'm just going to talk about state officers because it's more complicated on the federal side. And he just said, if you look at the Civil Rights Act when it was enacted in the 1800s, there's no evidence of any type of qualified immunity for officers. So really powerful argument. No one responded to it. The Northern Review reached out to a co-author, Aaron Neilson at BYU, and said, we wrote a defense of qualified immunity. So the defense, we call it the qualified defense of qualified immunity. And I'll kind of walk through it. Why, as a matter of law, qualified immunity under the Civil Rights Act should remain until Congress wants to get rid of it. Just start first with the text of Section 1983. We're going to read through that. If you consider yourself textualists, interesting. So in terms of statutes, there's kind of two big reversible fine. Those are those kind of follow the text of the law, that's it. Others might be more purposivist. They look at the purpose behind the statute. If you read the statute, one thing that should jump out at you is there are no offenses at all. It says every person under the color of statute or this regulation can be subject to monetary damages when they act under color of state law and violate someone's constitutional rights. And so one kind of argument people make is, well, there's no defenses, so the text controls and we're done. That's not an argument that Will Bailey makes because it's not a good one. When Congress enacts statutes, we assume they enact statutes against the backdrop, common law principles, and the laws that exist at the time the statute was enacted. No one's arguing, at least not yet, that we should get rid of judicial immunity or legislative immunity. It's not in Section 1983, but these defenses existed. So the question you have to ask is, do the defenses exist when it comes to qualified immunity? Did that exist at the time? And Richard made some great arguments that hey, it's not very strong. We don't find the type of immunities in the 1800s that qualified immunity is today. Aaron and I in response are like, we don't disagree. Like if this were like looking at it as an original or nothing else, it's probably the case that qualified immunity is clear cut in the 1800s. On the flip side, we can find some outlier cases and definitely statutes from Congress that suggest that Congress and the courts are recognizing immunities for executive officers when they make good faith mistakes. And it's not as clear a record to us as it is to Professor Bode. But maybe importantly is stare decisis. In other words, this doctrine in the Supreme Court was first recognized in the 1960s. It's been repeatedly referred by the Supreme Court over the decades since. It's a bedrock principle of Section 1983. And I know this is me being an old Burkean, traditional judicial conservative of let the law grow slowly, develop slowly. But for instance, like this is a bedrock principle, just like other cases that are being looked at to be overruled now or not. I'm in that camp, but it's really not the court's job to do that unless it's clearly wrong. And for Aaron and I, looking at the historical evidence, we don't find it clearly wrong. Now, importantly, this isn't just constitutional stare decisis, so we're not talking about Roe v. Wade or gun rights versus United, or this is statutory stare decisis, and the Supreme Court has said, and I fully embrace this, that there's a judicial precedent interpreting the statute. It's a super precedent. Why? Because if Congress doesn't like it, they'll get rid of it, or they have the opportunity to get rid of it. But when something wrong is a constitutional matter, you go through a constitutional amendment process, and there's reasons why you might allow the court to overturn a constitutional precedent, but not a statutory precedent. And here it's more than that. Congress has amended Section 1983 multiple times. They've actually changed immunities for judges, never touched qualified immunity. Congress has actually enacted qualified immunity in other statutes dealing with other types of officers, so they know it exists. And the argument is they legislate against the backdrop of it. So I'm not going to go to the next slide, I guess, since we're going to do the Q&A on that. But that's kind of the legal argument. One, the history is messy in my mind. It's not crystal clear as an original matter. And more importantly, it's the law going in. This is how the courts interpreted Section 1983 since the 1960s. So if it needs to change, Congress should be the one that changes it. Now, one other thing I think is, I'll mention this real quickly. Another really interesting article, if you want to kind of dive into this more, Scott Kelly had an article that came out in the Stanford Law Review earlier this year. And she took a deeper dive into the history. And he actually agrees with us that the history is very messy. He actually agrees that he's right about, and this is just too much, about the clearly established stuff, like that's not real, like that it could also be subjective intent. I don't want to put too much in that now. I mentioned this because Scott Keller is suggesting the court should reform it some ways, and I agree with his reforms based on it as an original matter. But kind of pull back on some of it. And I mentioned that because he was the Solicitor General of the state of Texas. And so another kind of strong conservative, not overturning that little bill, but conservative coming out and saying there's a regional matter that needs to be rethought, at least on the edges. And I would agree with that. That's something that the court kind of took a wrong turn in one of the cases on Professor Sisk's slides, which is the Harlow v. Fitzgerald. We can maybe talk about that later if we want to. Okay, so that's the law. What about the policy? Well, lots of empirical work has been done in the last decade or so to kind of understand whether qualified immunity is good as a policy. Remember, the policy, does it help states recruit, retain, and hire those people? Does it allow them to perform their duties to be in court? Does it prevent officers from being shielded? And I think the leading empiricist on this is Joanna Schwartz, a professor at the University of UCLA Law School. And she's done a number of studies. And the first is she finds that they're almost always indemnified. So in other words, if the rule is that you can't hire them because they're going to lose their home, who's going to do this job because they make a good faith mistake and they lose their home, then they lose their homes. And I think that's generally right. It's a little bit more complex than that, but I think that's generally right. She then also does studies looking at the effects on litigation. And she finds it has a 3% effect rate on litigation. In other words, it really doesn't help officers in her view. She also finds that it doesn't really stop plaintiffs' lawyers from bringing suits that have merit, but it does maybe stop them bringing frivolous suits. And she also finds it has no effects on officer training. We took a look at the last one. We took a look at the rest of them. And again, the first response, which if you're not just concerned with the statutory stare decisis, might not be your strongest. But the first is the statutory stare decisis. We actually don't care about policy. That's left to Congress. So if Joanna Schwartz has got these great studies, let Congress take them up and let that go. Courts shouldn't be engaged when they're overturning statutory precedents, looking at policy arguments. We'll do a deeper dive into some of the studies, and looking at that same data, just in terms of how you count it, we see that qualified immunity mattered in 1 in 3 cases in your study, which in our mind is a big deal. I mean, that kind of strikes us as like a pretty good filter. It filters out a third of cases that make it beyond to make it to the initial dismiss stage along those lines. So that's kind of, the studies are there. There's something to look at. I had to kind of talk through some of them in more, but ultimately we see the qualified immunity has an effect. And I have to say, after the murder of George Floyd, there's been a lot more empirical work that's been done. And I think Joanna Schwartz has had to do a little bit of a tap dance on this, because most of her work was to say qualified immunity really doesn't matter. Therefore, the Supreme Court get rid of it. And what we've seen since is qualified immunity really matters. Therefore, the Supreme Court must get rid of it. So there's a dance that's moving in the other direction. But and we haven't done these studies, we've only kind of consumed them. Where I'm at is it does matter. It doesn't close the courthouse doors for plaintiffs, but it does matter. And its current version goes too far. But the arguments that kind of were made early on just don't have as much sway. The last thing I want to just conclude on is federalism and state reliance interests. And this might seem kind of weird, because the fiction of qualified immunity, as Professor Sisk said, is that officers are sued in their individual capacities, because you can't sue the state because of state sovereign immunity. And so it's not an intrusion on states' rights or state autonomy or the like. And the answer that Aaron and I done in a paper that came out in Georgetown, the Georgetown Law Journal a couple of years ago, is it actually really does matter for federalism. And that's because states have to hire officers to fulfill the duties of democratic elected bodies. And they have to hire good ones. And if they can't hire good ones, that affects their ability to function. Beyond that, as Professor Sisk kind of hinted to, a lot of these officers are fully indemnified. So this is coming out of the state coffers. This is coming out of the public fist, out of taxpayer money. So taxpayer money is fungible. If it's being paid for litigation, it's not being paid for public services. So it does affect the state. And then lastly, on the flip side is states have a lot of room here to experiment. They can get rid of qualified immunity under state law. In fact, a fair number of states have experimented with this. Colorado and New Mexico got rid of this. New York City has gotten rid of qualified immunity under state law. There's not such federal law. Under Section 1983, we bring a lawsuit, it's still there. But they would say we're providing lawsuits, your ability for individuals to sue under state law and state courts, and we're eliminating the types of immunities that would exist to prohibit them from recovering in those circumstances. So where does this leave us? Well, one, my position is at the federal level, if qualified immunity should be changed, it should be Congress that does this. At least it should be reversed overall. The Supreme Court can call back on it. I mean, we can talk about that more in the Q&A. Really, it's a statutory precedent that's been around for 60 years, is our law. State courts and state legislatures don't have to follow lockstep with the federal. State legislatures can legislate away qualified immunity under state law, and state courts and state Supreme Courts have done this, can view and interpret them differently than how federal courts have interpreted immunities at the federal level. And you see state courts do this on a pretty regular basis to kind of carve back along those lines. So I think I'll stop there, and you can tell me I'm wrong. And
Thank you. Thank you. So in my presentation on the cons of qualified immunity, I want to make 4 basic points. I want to contend that qualified immunity is bad history. I want to argue that it's fictional. I want to contend that it's dishonest. And finally, and most importantly, I want to argue that it's unjust. So let me begin with qualified immunity is bad history. And Professor Walker spoke to some of these issues. There's just no historical basis, or a very limited amount of historical basis, for the idea that qualified immunity was a background concept that was assumed by Congress when Section 1983 was enacted in 1871. The closer we look at the historical timing, we find reasons to doubt that this is the case. And in fact, Alex Reinhardt has done a recent piece, which is beginning to get some significant attention, even though it's not published yet, that the original language of Section 1983 included another phrase that ended up being accidentally dropped in the codification, which doesn't really the original text. The codification is just evidence of the law. And that additional phrase said that the constitutional liability would be quote, withstanding any immunities that had arisen under state law. At the beginning of the American constitutional experiment, there was broad acceptance of a common law cause of action for damages caused by the misconduct of another person. And this included officials who violated the rights of citizens. Jim Fander explains that from the early days of the Republic, courts adopted common law norms to apply a fairly unyielding body of tort law in assessing the liability of government actors for the invasion of rights to persons and property. And during this time period, individual officers were not protected by governmental immunity. In the mid-19th century treatise, Justice Joseph Story explained that the personal liability of federal officers for positive legal wrongs would be excused by showing that they had acted bona fide or to the best of their skill and judgment. The second point I want to make is that qualified immunity is fictional. So let's look at what the stated theory is of the Supreme Court and how this dovetails, or in my view does not, with the qualified immunity doctrine. Stated theory by the Supreme Court is that a government officer is protected by qualified immunity if she reasonably misapprehends the message of the law. This doctrine then sets a standard for qualified immunity that is entirely pretend. We are pretending that pronouncements by appellate courts are being reviewed by government officers so that they can control their behavior according to the lines drawn in judicial opinions. And this is just nonsense. As Joanna Schwartz writes, their public officials could hardly be trained in the hundreds, perhaps thousands of judicial cases that clearly establish the law. Now, to make this fiction worse, the clearly established standard has evolved into a demanding exercise in parsing the specific details of prior appellate precedents. And too often courts appear to latch on to the slightest of factual distinctions from a prior case to excuse a defendant government officer. So a classic case of this is Baxter versus Bracey. A burglary suspect decided to surrender, sitting down, holding his hands up in the air. The officer unleashed a dog on him who bit him. We have a number of court precedents that said when a suspect has surrendered, you can't subject them to a dog attack. But the government argued, and the court agreed, that those cases could be distinguished. Because in one of the cases, the suspect was lying down when surrendering, whereas this suspect was sitting with his hands in the air. Another distinction was the earlier case involved an untrained dog, whereas this was an expertly trained dog. And I'm sure that this plaintiff was thinking how wonderful it was as the dog sunk his teeth into his arm. This is a well-trained dog. But the court used that as a basis for saying the law was not clearly established. Third, qualified immunity is dishonest. The primary argument for qualified immunity is that it protects the conscientious government officer from being held liable personally for damages in a civil rights suit. The reality is that doesn't happen. The fear that public officials will be left with ruinous personal liability for innocent mistakes is now understood to be without empirical support. Defendant officers in constitutional tort cases are invariably reimbursed by the government and are not held personally liable. And then fourth, and most importantly, qualified immunity is unjust. For example, the courts have regularly extended qualified immunity to a government officer whose state law wrongdoing is manifest. And I just want to mention two cases with respect to this, two recent cases. In Jessup versus City of Fresno, city officers executed a search warrant as part of an investigation into illegal gambling machines. The officers later provided an inventory saying that they had seized approximately $50,000 pursuant to the warrant. The plaintiffs claim the officers had actually taken $151,000 in cash and $125,000 in rare coins. In other words, the officers had stolen tens of thousands of dollars in currency. The United States Court of Appeals for the Ninth Circuit acknowledged the officers ought to have recognized that stealing money and coins would be wrong. But the court concluded, they didn't make clear on us that the theft was a violation of the Fourth Amendment, which the court said is a different question, and so qualified immunity was extended. In Evans versus Skolnick, a case that I handled before the Ninth Circuit, a prisoner discovered that correctional officers were eavesdropping on his confidential telephone calls to his attorneys. A small group of prison officials had circumvented the prison's secure telephone line. They had wired a loudspeaker directly into a tapped line so that they could listen to the entire conversation between a prisoner and his lawyer. The correctional officers admitted that they were doing this and listening to the substance of the conversation to, in their words, evaluate its legal substance based on, quote, legal terminology that you might hear on television. The dissent noted that the monitored calls involved civil rights violations by prison officials, including the same officials that were monitoring the telephone calls. And the dissenting judge also recognized that this correctional officer monitoring of prisoner telephone calls directly contradicted Nevada law. The Nevada state legislature had enacted a statute declaring that communications to a lawyer are confidential. And when that statute was enacted, the director of the State Department of Corrections assured the state legislature that calls would be placed by a prison employee to verify that it was a lawyer, and thus, quote, they would monitor that telephone conversation because it would be confidential. Nonetheless, the Ninth Circuit granted qualified immunity, saying that prison monitoring of legal telephone calls did not violate a Fourth Amendment right that was clearly established at the time. So in offering a scholarly defense of qualified immunity, Professor Walker and his co-author Aaron Neilson have grounded the doctrine in, quote, the theory that the prospect of liability for making a mistake about what the law requires may dissuade officers from faithfully executing state and local laws and policies that do not violate the U.S. Constitution. Well, the opposite should also then be true. The federal courts have no justifiable basis for excusing the officer who is hardly faithfully executing state and local laws and policies, but rather is betraying state and local laws and policies. If we grant solicitude to lawless government officers, the courts thereby are encouraging rogue behavior. Lawless behavior poses a serious threat to fundamental constitutional rights, and this is especially true if they are condoned by a later court decision that wraps that misconduct up in the cloak of qualified immunity. I feel that officials learn the lesson that they can flout law with impunity, knowing that they will be awarded qualified immunity without being punished for their wrongdoing. And so in sum, at the very least, when the government officer is a lawbreaker rather than a law enforcer, the very reason for qualified immunity evaporates. I think on some of the things that I just said here, Professor Walker would agree. I'll give him, do you want to take a moment to respond and then we'll
sharing, does that work?
Sure.
You want to stand up here so we can answer questions?
Sure.
I mean, so a couple of things on just real quick responses. So I don't disagree with Professor Sisk, but as a matter of history, that what we have today was clearly established, find a case on all fours, is what was in the 1800s. I mean, it's a really extreme, it's gotten more extreme. And if you take a class on federal courts, you'll kind of learn it's evolved in a way because the court is trying to kind of weed out frivolous claims and they overreacted. And so I agree with that. On the fiction point, though, I don't. It's not a fiction. If the original corporate was originally understood in the 60s, was that it was to excuse officers for good faith mistakes. And there are two ways to figure out if it's good faith. One, they have the subjective intent to violate the Constitution. If they have that, then it's not good faith. Even if they didn't violate the Constitution, if they intended to violate the Constitution, if they thought what they were doing was violating the Constitution, Supreme Court got rid of that prong. I'm in favor of bringing that back as one of the two prongs. So if, for instance, you see an officer, you have a video, it looks like they're trying to violate someone's constitutional rights, whether that's stealing money, and your examples, you should be able to overcome qualified immunity, at least get to the merits. But the other problem is officers need to not intentionally violate the Constitution. We also need to take affirmative steps to be reasonable officers that shouldn't violate the Constitution. And that's where the objective reasonable standard gets in. It's not a fiction. How do you figure out that even if the officer didn't subjectively intend, but they should have known that what they were doing was violating the Constitution? Well, you look at cases. If judges haven't announced that this is a constitutional violation, then maybe reasonable officers should as well. So it's not in my mind about, do the officers read all the judicial opinions? It's a matter of trying to figure out what was objectively reasonable. And the way to figure out what's objectively reasonable is to read the law. And so I think that in my mind it's not a fiction. It's a very good way of kind of figuring that out. On the dishonest point, these policy arguments, like the Joanna Schwartz has put together, they look at large police departments in big cities. They don't look at rural police departments or smaller police departments or municipalities. They don't look at non-police departments like social services, public schools, and the like. And I think it's a lot more complicated on that front. Not all executive officers are indemnified in smaller, and even when they are, there are weird type of sharing agreements that if you had a lot of liability, it could make some smaller cities and towns go bankrupt or have to do some pretty drastic changes to how they structure their tax and funding. The last point on the unjust, I agree, this is hard. Cases that find that when officers make decisions that are not based on good faith and lead to unjust results are awful. And the doctrine should be modified to address that injustice. But when officers make good faith mistakes, there's a lot of reason not to have liability there. The reasons we've talked about, hiring good officers, having them make split-second decisions. And I'll end on one. You could bring up cases. There was a case that came out of the Supreme Court, Camreta versus Green, about a decade and a half ago. And there, it was a public school teacher that had a student in an elementary school class, and she suspected that the student was being abused at home. So she called in the local law enforcement. They interviewed the student, and sure enough, the father was abusing the student. Father was convicted. The mother of the student brings a lawsuit against the public school teacher and the law enforcement officer and says, you should have gotten a warrant before. You had to get a warrant before. You either had to get permission from the parent, from the father, or you had to go to a court and get a warrant. There's no case on point that said you had to do that. But ultimately, the Ninth Circuit held those individuals liable for monetary damages. And you know, is that right as a matter of law? I think so. Like, you have to go get a warrant. Is that right as a matter of justice? I don't think so. You know, government actors have a really hard job. Think about your public school teachers. You got to make these decisions. If there's a child that's at risk, I say if there's not law directly on point, that's a good faith mistake. And we shouldn't discourage individuals from trying to protect other people's rights when they're doing their jobs. So
we should turn to questions here in a moment. I just want to point out one way in which I think there's some common ground between us, although we define it differently. I agree that good faith officers, particularly under constitutional provision like the Fourth Amendment, should not be held liable. But I would argue reasonableness is already baked into the Fourth Amendment. And so officers should be given a great deal of deference as to the decisions they're making, particularly under exigent circumstances where things are fast moving and there's a danger. And I think they still get that protection through the Fourth Amendment itself and that reasonableness standard. You don't need the additional layer of qualified immunity. But let's turn it over to any of you if you have questions or thoughts. Yes.
So I have some questions about if it sounds like you're maybe open to some reform with qualified immunity. So in most jurisdictions, the to be able to defeat qualified immunity, the burden is on the victim's family. Is that something that you would be open to discussing? And additionally, in Colorado, they essentially, when they got rid of qualified immunity, they capped it at 5% of the monetary damages or $25,000. And so that has huge tax implications. And so how can we have accountability for police officers without just emptying the coffers of taxpayers?
So let me speak briefly to those things and then Chris can as well. First of all, at least at the federal level on section 1983, in theory, qualified immunity is an affirmative defense and the burden is on the officer to show it. As a practical matter, though, I think because of this search for the perfectly clearly established precedent, it kind of works in another way. I am of the view that the better alternative to this is collective liability. These officers are acting on behalf of government agencies. We know the reality is they're being indemnified anyway. We should have liability there. And capping liability might make sense to me. When I see reports of various settlements that take place on occasion, I say, wow, that was an awful situation. Certainly the plaintiff should recover. But boy, that was a pretty generous settlement that was given. Sometimes I think public officials on city councils and county councils and so on, it's not their money and they become pretty generous in order to send the message, we're really upset about what happened to. And so putting some caps on that for purposes of limiting the taxpayer effect. The other thing that could be done and has been talked about is, at least in the police officer situation, requiring police officers to have insurance, in which case then they are protected both individually and they protect their agency because they have, and if they can't get insurance because they have a bad conduct record, well, okay, then they can't get insurance and they can't keep their job. And maybe that's another way to push police departments to get rid of bad officers. Whether that will work or not in terms of the market for insurance, I think is still a question.
Yeah, I mean, the idea of government liability instead of individual officer liability, I'm actually a big fan of individual officer liability. I think that if someone violates the Constitution, they should be the named defendant in the lawsuit, even though they might be identified later. Indemnification is something by contract, by state law. I mean, that can change. I really like the idea that the named defendant in a case is the officer, the executive officer. On the reforms, I haven't thought a lot on the burden of proof, but the two I would say, and I've already mentioned one, is we should bring back the idea of subjective intent. So you don't have to find a perfect case. You can plead that the officer subjectively intended to violate the Constitution, and that's enough. I think the pleading standard is high enough that you'd have to have more than just like possible. The other one I would suggest is get rid of this idea you have to have a completely identical case. Hope v. Peltzer's a Supreme Court decision where the officer won, but Justice Stevens right for the court said you don't always need an identical case if it's like obvious the Constitution prohibits that, that's enough. And you have seen the court in recent years actually reverse a couple lower court decisions on Hope v. Peltzer grounds. It was precedent in the United States. It's there. I think they should use it more and kind of just say, hey, if it's just so obvious, that this was a constitutional violation to any kind of officer, you don't have to show me a case on point. So those are the two main ones that I'd kind of put forward as things that the court could do, not just Congress.
Just so you understand, I'm not sitting down out of any impoliteness. As my students know, I became a cyborg by having both of my knees replaced, and so standing uninterrupted is difficult. I will say I'm encouraged by the Hope scenario, but one of the cases in which the Supreme Court applied that was an individual who was held for days in a cell, which was covered, the walls were covered with feces and there was no toilet. And the Supreme Court said that's obviously wrong. I'm sad to say that some lower courts have said, well, it really depends on the amount of time that you have to be in that cell that's covered with feces. And if it's not days, it's just, one day, maybe that's not, so the problem is still there. Yes, sir.
When you're talking about the possibility of eliminating qualified immunity, the emphasis here has been on police cases, Fourth Amendment police cases. But I think you keep in mind that 1983 doesn't limit cases to just police. Teachers, First Amendment rights, social workers are included, building inspectors. And they need that the same reason for having qualified immunity really applies to them, because they're not in a lot of these cases. You know, you're not going to have clearly established law with regard to them.
Yeah, so I don't know which way you're framing this. This is for me another reason why Congress should solve this, not a court. Because the court solution is going to be one size fits all. It just would get rid of qualified immunity. Congress can actually tailor it to specific types of officers. And in fact, that's what Congress did after the murder of George Floyd. The Dems' big Policing and Justice Act only eliminated it for law enforcement. You know, the first version actually eliminated it for prison officials too, and they took it out. I suggest when I've advised members of Congress, because some Republicans are also interested in this, you could limit it to just excessive force claims if you wanted. You could also limit it to just excessive force, eliminate qualified immunity. Limit just excessive force claims that lead to a death. I mean, so there are ways to kind of modify it. Maybe you're not in this camp. I'm in the camp that police officers are, this is a problem and we've got to address it. But when it comes to school teachers, social service workers, I actually think qualified immunity is much more, as a policy matter, much more important than it is in the context of police officers. So.
Yes.
So you both, I think you both kind of have a similar understanding that the idea that police officers might lose their homes if we get rid of qualified immunity is maybe a misconception or something along those lines. Does the data also show that police officers are aware of that? Is there data that shows how changes to the status of qualified immunity actually would affect the hiring rates?
So first, it is fictional. This is not happening. And even police officers who engage in egregious wrongdoing, almost invariably, at least at 99% rates are indemnified. And with respect to government officials, school teachers, school board members, and so on, the same is true. They're not being held individually liable. In terms of the impact this has, I haven't seen this myself, but the Institute for Justice, which litigates on this, and I've worked with them on some cases, referred to a survey that was taken of individuals who were thinking about a police career. And they found that they were very concerned about attitudes towards police after the murder of George Floyd. They were very concerned about how they would be treated in their community. They were not concerned at all about qualified immunity or personal liability. That just didn't rate as a factor in making their decision. So no, I don't think that it really, this is something that the opposition said. The county sheriff, whose video I showed, said, if we have qualified immunity is abolished, we'll never be able to hire a police officer again. I don't think there's any evidence to suggest that this is something really on the minds of candidates and whether they're going to go to the police academy or not. In part because they know, especially through police unions, they're not going to be held liable personally. They're going to be covered by that.
Yeah, the only thing I'd add is if you look at the Georgetown article that I had, we did a state-by-state survey of indemnification practices, and a lot of states don't indemnify if punitive damages are on the table. And so again, though, if punitive damages are on the table, you should lose your home and much more. I mean, you have to have done something really, really, really obviously bad and awful. Like qualified immunity shouldn't be screening that out. But Joanna Schwartz's study doesn't capture all of that. In fact, she's kind of revised her view on this because she only focused on large police departments. She didn't look at smaller and mid-sized police departments. My guess is, at least anecdotally, officers that have punitive damage on the tables don't get indemnified.
I know we have these classes at 1:30. If you're a little bit late, blame it on me. But for those of you who don't need to leave right now, quietly walk out. We can stay. I don't think there's anything in this room, so we can continue to. I don't think there is, so we can continue to talk for a little bit longer. So for those of you who can stay for another minute or two, any additional questions? I thought I saw one.
So this is from online.
Yes, yes. Let's take 15 seconds to let the room clear. Thank you for coming. You're welcome. All right, do we have an online question? Yes.
So it's, should qualified immunity be determined only as a question of law by the courts and only after the disputed facts are determined? Also, if the doctrine of qualified immunity is outlawed, how can the object of the doctrine be otherwise?
So the current doctrine is interesting as to how that works. So,
Class in here at 1:30, so we should.
oh, is there? Okay. So I'll answer this question fairly quickly. The Supreme Court has held that if there are disputed questions of fact, it has to go forward through discovery in order to determine what those are. And in fact, those who try to appeal early, officers who try to appeal early, have to accept that the facts are as they're stated in the pleading or as disputed before they can do that. So it's a little bit more favorable to plaintiffs under those circumstances.